Hi, Attorney Andrew Thompson with the Thompson Law Office in Carmel, Indiana. In this segment relating to foreclosure issues in Indiana, I'm going to talk about quiet title actions and the power of a quiet title action on behalf of a homeowner and dealing with issues with its lender. We talked a lot about defenses to foreclosure, other defenses in mortgage-related issues. And now we're talking about a situation where the lender hasn't actually filed for foreclosure, but yet they've made mistakes in the process which have created a situation wherein you properly have rights to be enforced to title to your property that may have eliminate the mortgage, cause the mortgage to be reformed or renegotiated by the lender, and the debt or promissory note itself also to be renegotiated. Now, I think it's really important to try to give some examples of what happens here, what the duties are on the part of a lender that create these situations for you. So I'm going to rattle off a few pretty quickly. Number one, let's talk about the defenses that we have and where that might create quiet title claims for you. So let's say that even though the lender hasn't filed for foreclosure, you have evidence through title work or other documentation that there's been an improper assignment of a mortgage, an improper endorsement of a promissory note, or that the promissory note that evidences the debt cannot be produced by the lender. Now, those things are difficult to prove unless you get into a foreclosure action. So let's talk more about things that you can produce evidence of. And that would be negligent acts on the part of a lender. Now, in an earlier segment, I mentioned that while there may be very valid reasons, there certainly are duties on the part of a lender in going through the process, that the proof of negligence, when it comes down to the proximate cause of actual damages to you based on what the lender did, can be more difficult. But there are situations in which what a lender has done in initiating the process is so severe, so damaging, so harmful that you're entitled to recovery. You're not just entitled to quiet title on your property, but you're also entitled to some form of recovery for their actions. Let me give you an example. Okay, let's say that you bought a property, maybe 5 years ago, 2006. Okay, it's 2011 now. And you brought that property on land that had been in your family for years, and you bought it from a cousin, an uncle, someone that you knew. And in all the time you've been around the property, the 35 or 40 years of your life, it had never been flooded. And it had never been flooded because there haven't been the heavy rains around the area that would have caused it to flood. But yet, in closing on the loan, the lender, by federal law, was required to have a flood assessment done. And at closing, you paid for this flood assessment. And at the closing, you were told by the mortgage originator, and possibly even reassured in writing or verbally by the lender, that no flood insurance riders or addendums were required on the property. 2 years later, 3 years later, a flood comes along and damages your property. What you find is not just that the property should have been insured and that the lender should have known that at the time of closing, but in actuality, no assessment had ever been done because you're trying to do your research now to determine what did happen. Okay, so now you're talking about severe damage to property, maybe as much or more than the value of the property itself or the loan that you have owing to the bank has been done as a result of that flood, and ultimately as a result of the negligence on the part of the lender. Okay, that's more than a game changer. That puts you in a position where you have a claim against the bank. Now, to most people, that looks like routine negligence to a lot of attorneys, where you have a kind of a personal injury claim for what the bank did wrong. And I think that's true, and I think it's a question of professional commercial liability on the part of a banking institution, and it's probably got significant insurance coverage on that particular claim that's going to help you recover from them. But all that said, let's look at the reality of the situation. This came about as part of a closing on your loan. it certainly raises a question. While it doesn't prove, but it certainly raises the question of what else might have been done in that process, in the process that brought you to the point where you're at today and you're paying this loan, maybe to another servicer on the loan, okay, that needs to be dealt with. So a quiet title action can work in your favor based on what it does in terms of the foreclosing on the interest of the property itself. But while you're evaluating the quiet title action, it's also very important to consider claims for recovery that you may be entitled to. With respect to quiet title action itself, in the law and the way it's carried out in the course of litigation, it's very different than a negligence claim. It's different from the standpoint that it's a case of equity, which means there's no jury involved in the decision about quiet title, and that's fine in this instance. But it can be raised at the same time and in the same action that you raise your other claims against the lender, if indeed you have any. So it's a very powerful vehicle on your behalf, and you should consider all the errors and omissions that may have come into play. And if you're confident that in fact that there are those errors and omissions, it's your right to quiet title on your property and have a properly formed mortgage, if indeed any exists and is valid on the property at this time, so that your interests are fully and completely protected. Call us today at the Thompson Law Office. Let's talk about your situation, how we might be able to help you accomplish what you need. Our number is 317-564-4976, or feel free to call us toll free at 877-365-1776. I'm sorry, 877-365-1776. Thank you.